So I would say Alex Murdaugh, when he was first taken into custody, not taken into custody, but interviewed, he was giving statements to police. And of course, what's come to light is they've downloaded the cell phones of his son. They've downloaded his cell phone. They've looked at all the phone records, GPS locations, talked to all the witnesses in the case. And there's been some inconsistencies.
Well, what the defense is maintaining here, and by the way, for those of you that are unaware, he's pleaded not guilty to 2 counts of murder and 2 counts of weapons charges in the killings. What the defense is maintaining, that this guy is a loving father and husband who called 911 the night of the killings after he found his wife and his son shot at the family's estate in South Carolina. That's what they are claiming. But there are a lot of, and you're right when you say there's a lot of circumstantial evidence. It's not like there's DNA and well, we know he did this, we know he did that.
Well, here's the thing. There's DNA everywhere.
Right.
It's his DNA. He lives there. So DNA is not going to tell you anything.
Right, but I'm saying a murder weapon,
they never found the murder weapon.
Right.
They never found, and this really came to light, his clothes that he was wearing that day. When you see the video interview that's presented at trial, detectives were always trying to find this white T-shirt that he wore. They sent that off for testing. They sprayed luminol on it for blood spatter. Come to find out, when they downloaded his son's phone, there was a Snapchat from earlier in that day where he was wearing different clothes, khakis and a light blue shirt, and that he changed clothes.
But they're claiming that's not abnormal, especially with the weather and the humidity.
No, what they're claiming is, what they're trying to say is that he wasn't even wearing that, because come to find out, when he talks to the housekeeper later on, months down the line, he says to her, she testified. This is riveting testimony. The housekeeper gets on the stand and says, Alex came up to me and he says, hey, remember the day of the shooting? There's this picture. And I didn't know what he was talking about. But they said, this is this picture. And you remember what I was wearing that day, right? And he kind of tells her, remember what I was wearing? I was wearing this. I was wearing this particular shirt. And she's like thinking about it in her head. She goes, no, you weren't. And actually, she testified that he did change clothes that day. And so what the defense is saying is, well, you never asked for these clothes. When they were cross-examining the detective, you never asked for this clothes. You never asked for it. And they really did tear apart the detective like any defense attorney can do. And as a prosecutor, I saw it a million times. All the things the detective did not do that they should have done. But he changed his outfit. And that was strange. That was peculiar, right?
But if you change your outfit, that doesn't necessarily mean that you're a double murderer either.
Well, if you do shoot somebody at close range, and that's what the ballistics experts and the blood spatter experts are saying, that like these were close range shotgun shots that were fired, there's going to be blood splatter on your clothes. So if you do commit a murder at close range, you're going to dispose of your clothes. I don't know how many cases have been solved because you go to the guy's house and you find the clothes and you link it through, there's blood of the victim on the clothes. And it's like, how do you explain that? Here's Alex's story. Alex's story to police, and what they're maintaining at trial is one thing, but the burden's on the prosecution. So all we're going off of was his story to police, and they played the entire interrogation on video for the jury. His explanation to police is he was at the estate with his wife and son. They have a huge estate. There's a dog kennel that his wife and son went down to. And down at this dog kennel, he says, my wife and son, after dinner, they go down to the dog kennel. I don't go with them. I stay up at the house. I take a nap. His mother is very elderly, and his dad was very ill. Actually, he went from like ill to terminal, like right around that time, maybe even that same day. Because I took a nap upstairs. I didn't go down to the kennel. And then I went to go check on my mom. And when I came back, I found them dead. And I called 911. All right, this is where the circumstantial evidence, and people think circumstantial cases aren't strong, but circumstantial evidence just means that this is not direct evidence. No one saw you directly shoot them. So we're linking it by circumstance. Sometimes circumstantial evidence is the strongest evidence in a case. When they download his son's phone, they see that his son took a video down there at the kennel of the dogs. Like, hey, get back, boy, get back. And you hear his mom's voice, and one of the dogs had a bird in his mouth, like some chicken it had caught, and is running around the yard. And they're like, he's got a bird in his mouth. And you can hear Alex Murdaugh going, hey, hey, hey. And multiple witnesses who know the family very well have come up and said, 1,000%, that's Alex Murdaugh's voice, 1,000%. So, okay, why did you tell police you never went down to the dog kennel when we have at 8:47 p.m.? They think the murders happened right then at like 8:50, like right then, right around 9 p.m. That's when the murders, they're linking that together. They go, how are you down on a video at the dog kennels right before the murders happened? And then you told police in your interrogation you never went down to the dog kennels.
And they had friends of the family that testified, I recall, and they all said beyond the shadow of a doubt, 100%, that's Alex Murdaugh's voice.
Oh,
several.
Yeah. That's his voice. That's his voice. That's his voice. And it wouldn't be anybody else. So then you have that. And then he does go to his mom's house, right? And so he says, hey, I was at my mom's house. Basically, they provided a notice of alibi. I was at my mom's house checking on her at the murders, and then I came back. Well, we see you're down at the dog kennels right before the murders, and now you're saying you're at mom's house for 40 minutes to an hour. Well, he talks to the housekeeper at his mom's house, and the housekeeper testified the other day. She gets on the stand and she goes, yeah, he was there for like 20 minutes. And, you know, now look, could you be mistaken of 20 minutes or 40 minutes as a housekeeper? Yeah. But Alex needs it to be 40 minutes because 40 minutes means I was not at the murder scene. I have an alibi. She says 20 minutes. They download his OnStar from his car. Guess what? 9:21 to 9:41 is when your OnStar was driving away from there and then leaving. So the 20 minutes is corroborated by OnStar. Guess what? You could have done the murders and then gone to your mom's house. Why? Because you're establishing an alibi. Now you're seeing the theory of the prosecution come forward, right? And then the housekeeper says in the same conversation, he goes, hey, aren't you getting married soon? You're going to be getting married, right? Weddings are expensive. Let me know. I'm going to help you out with it. And then he actually told her, if anybody asks, I was here for 40 minutes.
Yeah, very bizarre behavior.
I mean, come on. Now you're sitting there going, all right, how do you explain this away?
Thomas, I believe that he killed his son and his wife. Okay. I believe this happened. The problem is, and I'm not saying you can't be convicted without a murder weapon. I'm not saying you can't be convicted without other evidence that clearly has not been provided by the prosecution in this case. I do believe he's guilty. However, we don't have a murder weapon. We don't have the clothes that he was wearing allegedly when the murder took place. That's an issue. I believe he's guilty based on what you just spoke about. Him lying about where he was at that time is, to me, first of all, the only reason why you would lie about something like that is if you were guilty. Let's just call it for what it is. He doesn't have Alzheimer's, okay? He's not the kind of guy that has a medical history of being forgetful. The only reason why you lie about something like that is if you're guilty.
Well, everybody on the jury is going to be wondering, if your wife and son were just murdered, why? Yeah. Why would you say you never went down to the kennels?
You lied.
Yeah. And then the house, and then you're telling your housekeeper later, hey, remember what I was wearing? There's a picture out there. I'm kind of worried.
Yeah.
Say I was wearing this. And then why would you go to your mom's house and then tell her caretaker, hey, I was here for 40 minutes,
well,
and then offer money?
Because he just killed 2 members of his family. That's why.
Well, he's trying to establish an alibi.
Of course.
So the cell phones tell all, right? So they get the cell phone forensic expert on the stand, and this cell phone forensic expert says, hey, we're looking at every time you pick up, I got an iPad right here. Every time you pick up your cell phone and you switch it around, it records an orientation change, even if the screen doesn't light up, because I went from vertical to horizontal, right? Every time you touch a button or anything, you notice your phone lights up, there's notifications, it records that. And this is how they're timing the death here, because the whole Alex Murdaugh, for him to mount a credible defense, he has to basically corroborate his own story to police that night. So the timing of the death of his wife and son has to be wrong. And so what prosecutors are relying on is cell phone evidence, going, hey, we're getting cell phone action on these phones. And then at a certain point in time, right around 8:55 p.m., there's no action for about an hour on those phones, and they lock, and they're never unlocked again. So we think that the wife and son were murdered right around that time.
With all the evidence that we've talked about here, and thus far in the trial, which is clearly not over yet, by the way.
Well, the defense hasn't even started presenting their case.
Right. It's not even half over yet, really. Do you believe that the jury will find Alex Murdaugh guilty of double murder?
I think the real damning piece of evidence in the case is he's down at the kennels with his wife and son, and he lied to police about ever going to the kennels. You might be mistaken about a few minutes here and there. You might be mistaken about those things. But to say I was never down at the kennels with them, when in fact you were down at the dog kennels with them, and there's video corroborating that. And what it looks like is these phones were manipulated around 10 after he made the 911 call. It looks like these phones were manipulated, the wife and son's phone. Their orientation changes, the screens were lit up, tried to interact with Siri. Do you know how on your iPhone you can kind of pull your camera up without unlocking it? You can take a picture. Oh, you don't have an iPhone.
I don't.
You got to upgrade, man.
I got a Droid.
Yeah, but on an iPhone, you can actually open up your camera without unlocking your phone and take a picture. And someone was trying to do that. So it looks like Alex Murdaugh was actually trying to get into maybe his son's phone after he called 911. So these kinds of things, there's no explanation for it. Now, he's presumed innocent, but he almost needs to take the stand to try to explain some of this away. But man, he'll get roasted on cross-examination by the prosecutors for the inconsistencies about the dog kennel video. And then the Snapchat photo, you know, you have that too. So what comes to light is the CEO from his law firm testifies that we started finding out that there's a lot of money missing, millions. We're talking 7, 8 figures, millions are missing. And I confronted him, and it was the morning of the shootings. He said, went over to his office and said, Alec, I think that the client funds went directly into your personal bank account, and you need to prove it to me. Prove it. Disprove that right now. And then he just kind of said, yeah, I'll be on it. I know, you're wrong, da-da-da-da-da-da. And what came to find out is after the killings, of course, the whole legal community there got behind him. And his own legal secretary said months later, come to find out through tracing the checks, that he did actually deposit some of these checks into his account. Had been ongoing for some time. But at the moment after the killings happened, it was like embezzlement. The law firm was like, what embezzlement? Like they were worried about his mental health, his emotional health. They were coming to his defense. And so that's the theory of the prosecution bringing in. They basically brought the whole thing into this trial, and he admitted that he stole the money to police. After this, he admitted it completely. They brought this all into the trial, saying his motive for killing his wife and son, because this is what it comes down to, right? This is a whodunit. Was it Alex Murdaugh or not? So what would be your motive for killing your wife and son? And what they're trying to say is, well, he had these financial troubles. He had the lawsuit that was coming down, and then he was getting caught by his law firm, but there's no life insurance money. So it doesn't really make sense, right? So what the prosecutors are trying to say is he was just trying to buy himself some time. He was panicked, and he was trying to delay the lawsuit, and also trying to delay, buy himself some time, his law firm coming after him. So he decided to kill his wife and son. And then since his son was really the culprit in the DUI boating accident, maybe that would have been deflected somewhat if his son was out of the picture. This to me represents one of the biggest issues in the case for appeal, legal reasons. The judge allowed this in because you're not allowed to try somebody like, let's say you commit an armed robbery. I can't just bring in, some theft case that you did 3 weeks prior, unless there's a reason for me to bring it into your armed robbery case, because you're just painting you as a bad person. And so the reason the prosecution gave is like, it goes towards motive and it goes towards ID. And the judge says it does. But I haven't seen appellate courts really frown on bringing past crimes in, or past bad acts is what we call them, unless it's really probative on an issue in the case and it's not unfairly prejudicial, meaning the jury's not going to look at you like you're a piece of scum because you're doing this bad stuff, and now we're going to convict you on this crime. And I haven't seen a lot of case law where it's easy if there was life insurance proceeds. It's like, of course, he needed the money. Okay, we're bringing this in. Right. But he didn't stand to benefit financially. So the theory is that he's deflecting attention by killing his wife and son. That is going to be a big issue on appeal in this case. If convicted, and it looks like based on the evidence I've seen in trial that he will be convicted. But look, there's 12 jurors, and you're right, they didn't find a murder weapon. But that could be a basis for reversal. Where courts love to reverse cases for trial judges mistakenly letting in really bad stuff. And so what the trial judge did say is, we're not going to let you bring in the 2 months after the fact where he organized the hit on himself. We're not going to let you bring that in. Prosecutors wanted to bring that in too.
I read an article that he was spending upwards of $50,000 a week on drugs.
Yeah, 50,000 a week or
It's a lot of money.
50,000 a month. There's no way, Brian. I mean, I'm not in the drug world, and I know he's prominent, so he's like getting the good stuff. 50,000 a week on drugs?
It's a lot of money.
On drugs? How much drugs can you do?
Well,
it's not like he had a pill problem. It's not like he was going in like drugs and hookers. He was home.
Yeah. I don't know. That's a good point, but I don't know what drugs cost because I don't do drugs. But that's the story that's out there. Clearly, he had an issue with taking a lot of pills, but $50,000 does seem a bit excessive. A week? He's spending $200,000 a month?
It is, but the defense is going along with this because here's what they're trying to say. They're going, he admitted he stole the money from the law firm. He admitted he stole money from clients. He admitted that he has a big drug problem. Okay. And I don't know if you ever seen Devil's Advocate with Keanu Reeves.
I did.
All right. Well, you remember the guy who used to play Coach.
Yep.
And he was the bad guy, right?
Yep.
And what did Keanu Reeves start out with? He goes, I don't like my client.
Mm-hmm.
He's this, he's that, he's this, he's that, but he's not a murderer, you know? And that's kind of like what they're going with. Like, he was honest about all this. But I'll tell you, here's what really, this is a bombshell a couple days ago because the judge said you can't bring in the stuff about the roadside shooting that he organized on himself. You can't bring that in, right? So the defense gets up in cross-examination of the lead detective in the case and starts poking holes. They're starting to plant the seed for there's alternate suspects you did not investigate, right? Mm-hmm. That's a good defense strategy, right? Mm-hmm. If it's not Alex Murdaugh, who was it? And so you attack the police by saying you didn't investigate all the leads. You just focused in on Alex Murdaugh, and this is who you came after, and you did A, B, C, D wrong. But look, there's other people. And they start saying, well, you knew he had a drug problem, right? They go, yeah. And you knew he had he owed people a lot of money. He owed some bad people some money, right? He goes, yes. He goes, all right. One of those guys was this guy, Cousin Eddie. Cousin Eddie is the guy who actually did the roadside shooting on him, that organized it. Cousin Eddie's like part of the Aryan Brotherhood or something, and he's connected to these drug dealers. And so they're going, all right, so Cousin Eddie, did you ever download his cell phone? No. Did you ever investigate all the drug dealers that are known in this gang that they could do a vigilante hit and send a message to Alex Murdaugh, we want our money? And the officer's like, well, the detective's like, well, no, they weren't. The word on the street was, and look, this is that they weren't worried about getting their money because Alex Murdaugh got money. Right. They're going to get their money, right? And so they weren't worried about that. But what happened is, look, the detective knows before he gets on the stand. The defense attorneys know. The prosecutor knows. Look, this whole thing about the roadside shooting can't come in. So even the detective on the stand, he's like watching how he's answering stuff because he knows I don't want to jeopardize the prosecution here. And the judge said we can't talk about this. But the defense is really creeping around saying all these alternate suspects. And so they go for a break, they go for lunch, and they come back from lunch. And the prosecutor goes, Judge, before they continue their cross-examination, man, I think they opened the door to this roadside shooting. And the judge goes, I agree. You tried to dance through the fire. And because, well, here's the thing. Let's say we're in a trial, you and I, and I'm defending you, and we do a motion to suppress the search of your house where they found all these drugs. And I win the suppression motion. The search, the warrant, they didn't get a warrant. They shouldn't have been in there. The drugs don't come in. Okay. All right. We go to trial. That's a huge win for us. They can't bring the drugs in, but they think they have a case against you some other way. Well, I cannot now insinuate through my opening argument, through my questioning of witnesses at all, that you did not have drugs found in the house. Like, I can't go up there and go, so detective, I mean, it's not like you didn't recover drugs from the house, right? All of a sudden, it's like you just opened the door to it. It's one thing to suppress evidence. It's another thing to lie to the jury or misrepresent what the real facts are. So now that he's going all these alternate suspects, it's like, bro, these aren't alternate suspects. We know Cousin Eddie didn't do it because Cousin Eddie was the shooter in your roadside shooting who you worked with to try and get your life insurance money. And you know all these gang members. There's this huge relationship there. So the prosecutor comes back from lunch and says, they opened the door. They opened the door. And the defense did. And it was a huge mistake. And I've seen it a million times. I've seen it a million times from defense attorneys. Because they're trying to establish their defense. But in trying to do that, they try to dance through the fire. And I've been in trials where prosecutors, we sit back and we're like, oh, this questioning, They're opening the door, and we're chomping at the bit as a prosecutor. You're going, oh God, we wanted this evidence in so bad. And maybe if the judge had just let us bring it in originally, it would be an issue on appeal, like the fraud, like the financial fraud stuff. But when you open the door to it, you can't put a fraud on the jury.
Right.
So now it's like it's wide open. But what was really funny, and I've seen these prosecutors make a lot of missteps, is the prosecutors come back from lunch in the middle of cross-examination, go, Judge, he opened the door. He opened the door. He opened the door. And the judge is like, okay, he's in the middle of cross-examination. Like, this isn't the time for you to bring this up, right? Yeah. And he's like, well, Judge, I just feel like I should be able to ask all these questions about the roadside shooting. We should be able to get into this. And the judge goes, you want to ask the questions right now? He's in the middle of cross-examination. You can't ask the question. He goes, I think they opened the door. And finally, the judge goes, I agree with you, but let him finish his cross. And this is when I look at these prosecutors like amateur hour. I've seen this from these prosecutors a lot in this trial. Amateur hour is if a guy's opening the door, okay? It's like if you go fishing, you go, oh, the fish is nibbling, it's nibbling, it's nibbling. And you all of a sudden you're jerking your fishing rod out. You're not getting him on the hook. You got to let him set that hook. So you go to lunch and you're all excited. You're sitting there at lunch going, man, they're opening the door. We're going to get this roadside shooting in. Can you believe this? And then you come back from lunch, you sit down and you let him finish his cross and you let him dig even deeper and deeper. And then before you start your redirect, which means, the prosecutor gets to get up again after cross and do redirect. You go, Judge, can we approach or excuse the jury? I got to bring something up. Yeah. After he's completely, but what they did, if the judge wasn't in agreement, they fully opened the door. You're basically telling the defense, like, watch it. You better watch out. So I was like, that was pretty amateur hour, but the judge agreed and said, okay, you can, you're going to get into the roadside shooting. So the defense goes back, and since it's all on YouTube now, the defense goes back after the trial and they watch YouTube, and they come in the next day and go, Judge, we did some research. They had a case, State v. Hayward, a South Carolina case about bringing in bad acts. And they're like, we did not open the door on this. I went back to YouTube. This is what I said, A, B, C, D. I didn't open the door. And the judge is like, okay, you kind of cherry picked a few things that you asked yesterday, which was not the bulk of why I said you opened the door. But they tried to make a record because they knew they stepped in it. So then they step in it even further. They go, all right. They said, we've talked to the prosecutor. We're objecting to this testimony, but if it's going to come in, we're going to let him bring everything about the roadside shooting in through the detective who investigated the roadside shooting, meaning hearsay. You've heard of hearsay, right? They're like, we're just going to you don't need to bring in the 911 callers. You don't need to bring in the doctors who treated him for his gunshot to the head. You don't need to bring in the witnesses. You don't need to bring in Cousin Eddie. You don't need to bring in any of these people. Just get in all through your detective, because we're just going to be, expedient for trial. We've been in trial for 2 weeks, and so we'll do it that way. And I'm going to tell you, as a prosecutor, defense attorneys always do that, and we love it. We loved it as prosecutors. We go, wow, because without you agreeing as a defense attorney to let me just bring it all in through my detective because it's hearsay. He doesn't know what the doctors did. He doesn't know what the EMT saw. He doesn't have direct knowledge. You can only testify in trial to things you have direct knowledge of. So the prosecutors are sitting there. We can get all this roadside shooting stuff in, but my first thing, if I was them, I'd go, but it's not like we have the EMT sitting outside the courthouse, the 911 dispatcher subpoenaed for trial, Cousin Eddie ready to go. We don't, and like literally, we're at the end of our case in chief. Like, we need to have these witnesses here. The judge is going to go, yeah, let's just pause trial for a week so you can get all these people together. Right. The judge is going to say, no, you're not ready to go with it. We're going to end your case. And so you're sitting there like, damn, how am I going to get these people in? And then the defense goes, so you go over there and go, hey, and this is what prosecutors do. It's called sliding the ball past the goalie, right? You go, hey, it's like, look, man, we're in trial for 3 weeks. Do you want me to bring all these witnesses in? It's going to look so bad for your guy when I bring all these witnesses in. I just come and get it in through the detective. And the defense goes, yeah, that's fine. That's fine. And so the prosecutor, this was not amateur hour. The prosecutor gets up and says, I just want you to know, Judge, that we're in agreement with all this. The defense says, yeah, we're in agreement with everything. We're objecting to the testimony coming in, but if it's going to come in, we're in agreement to how it's going to come in. And the prosecutor goes, just for the record, this is a tactical, strategic decision on the defense. So on appeal later, it's like, hey, because post-conviction attorney is going to look at that and go, how could you not make them bring all these witnesses in and do it the right way? Because they might not be ready to do it. So the prosecutor did a good move there. When you see it really come back to bite them in the foot is today's testimony. Okay. The detective from the roadside shooting comes on and he testifies. The prosecutor gets everything he wants out of him, and the defense goes up to cross-examine him. And the defense thinks, I'm going to be able to cross-examine him on all the issues that you were able to ask him questions on. And the defense says, so basically he was shot in the head, right? And here's how detectives are on the stand. You know, they know you're trying to basically blow up their prosecution. So as a defense attorney, the detective's never going to give you an inch on anything. So he goes, I just know what the doctors were saying. He goes, okay. So the defense attorney's like, you're not even going to agree that he was shot in the head here. Did you review the medical records?
I did not. No.
And he goes, well, yeah. The detective goes, well, I believe I did. He goes, all right. Can I approach? I got the medical records right here. Take a look at this.
Oh, jeez.
And so this goes on for 20 minutes.
Yeah.
Finally goes, would you agree the medical records state that he has a gunshot to the head? And the guy goes, well, I'm not a doctor. I can't read these medical records.
So do you think he even reviewed them?
The detective?
Yeah.
At some point, he probably looked at
Probably
him,
just skimmed him over. But yeah.
here's the whole point. He doesn't have direct. He's not a doctor. He didn't diagnose. So he can always fall back and say, I saw a laceration to the back of his head when I got to the hospital that would have been consistent with a gunshot wound, but I'm not a doctor. And now the guy's like, the defense attorney's like, listen, all right, did you ever tell Alex's sister that he was shot in the head? And the detective's like, and he goes, it's a recorded phone call. I could play it for you right now. And the detective's like, well, I mean, I'm not disputing that it happened. I just don't remember recalling actually telling her that. He goes, I'm not disputing that Alec was shot in the head. And after 20 minutes, the defense attorney goes, I mean, I think we're having a problem communicating. I mean, it took you 20 minutes to finally say that he was shot in the head. That's all I'm trying to get out of you. And this is how the detective was for all the testimony.
Right.
And so not only did you let the prosecutor get it all in through the detective, now all your modes of cross-examination on this detective are frustrated by a guy who is a professional frustrator on the stand of defense attorneys. And it's a big misstep by them. I mean, Jesus. Yeah. But I would be remiss if I said I didn't see that happen all the time. But you would think in a trial, I understand when a defense attorney wants to get back to his office to sign another client. But this guy Harpootlian and his co-counsel, I mean, this is like trial of the year for them, maybe trial of the decade for them. It's on national TV. Everybody's watching it. Right. If this trial has to go another week, make it go another week. You make the prosecutor bring those witnesses in. Because if they can't bring the doctor in, well, guess what? A lot of this stuff from the detective comes in after the fact. He doesn't have personal knowledge of anything. So a huge misstep by the defense. I don't think that's what's going to lead to his conviction. But the fact that they opened the door to this coming in, then they let the prosecutor just squeeze it in the way he has. I call it, it's amateur hour again.
I do believe that he will be found guilty. I believe Murdaugh will be going to jail for the rest of his life. Maybe parole, possibility of parole in 30, 40 years. But that's what I believe is going to happen. We'll have to wait and see what happens because, as I said, we're barely halfway through this trial. The defense hasn't even had an opportunity yet. So,
well, let me tell you this. What do you think about this? They get the blood splatter expert guy and the ballistics and everything they show. And I don't know. Do you shoot firearms? Have you ever shot a shotgun?
I have.
Okay. Yep. That shotgun stock has to be right up against your shoulder, right? Okay. These things kick like a mule. So the son was shot twice with a shotgun. And so one trajectory was parallel to the ground as if you were holding it the stock to your shoulder, the way you should. The second shot looks like it was coming from an angle down low. And the defense really made a big point of this when they were crossing the blood splatter expert, Dr. Kinsey, that it was a low angle. And everybody who shot a shotgun knows, like, you would never shoot a shotgun from that angle. And the prosecution's trying to say, well, you know, these shooting scenes are fluid. The victim's moving, the shooter's moving, but they made a big point of that second shot coming low. And what they're trying to say is this is the kind of how they're trying to paint this picture is, look, maybe there was multiple shooters there. It wasn't Alex Murdaugh. He was not on the property. Multiple shooters came in because why would you have those two very, very distinct angles? The first guy, if he's shooting up top, why would his second shot come to where he's almost holding it to where he has to crouch down to where he has to shoot at an upward angle?
Right.
And so that's kind of what they're painting. So what do you make of that?
As far as the shooting angles go, I'm not really a professional. I understand what they're trying to do. I think there could be a number of different reasons why those angles were what they were. What we do know, and again, I go back to what we said to start, and then we'll take a break. This guy's lying. He's lying about multiple things. It's been proven. He's not telling the truth. I don't care what he's told the truth in the past about stealing money from clients, whatever. So what? To me, that's irrelevant. We're talking about two people that are dead that were murdered. We're talking about a member of the family that is lying about where he was at the time of their deaths. To me, that is the biggest evidence. Why would he be lying about it, where he was when his son was murdered and his wife? To me, that speaks volumes. And I know we don't have a murder weapon. And I know that not everything is perfect here. We don't have his clothing when the murder allegedly took place. But what we do know is that he's lying. He's lying about where he was. He's trying to find out an alibi. And that speaks to one thing and one thing only. I believe he's guilty. Will the jury find him guilty? I hope so. We'll have to wait and see what happens. Thomas Moskal joining us, former prosecutor, talking, of course, about the Alex Murdaugh case. We're going to take a break. If you want to call 702-22. Again, that number to call if you want to be a part of the program is 702.